Yeah. Good. Who is this? Redmi 9. Who is this? How do you know that? Huh? Oh, thank you. Good evening to all of you. Yesterday, after we closed the classes, there was one question asked by someone on the chat box as to what is the liability of a partner. In fact, if you can see, I've already given a reply in the chat box itself that the detailed reply has been given. Here again, but if you have not seen it, I'll repeat it. Here, the incidence of partnership is the two or more. I told you the definition also. As far as the liability of a partner is concerned, it is joint and several. And every partner is an agent of the other. Every partner is a trustee of the other. Every partner is a manager of the other. And every partner has got mutual responsibility towards each other. Here, the question that was asked is liability of an individual partner. I don't know who it is, but I received it on the chat box. I replied to it also by giving a message. But here, as far as the liability is concerned, there is no question about it. The liability of a partner is joint and several. So long as they are partners in a firm, the partner cannot escape his liability. The only exception being if the erring partner or the person who commits a mistake or fraud acts beyond the powers that is given to him under the deed of partnership, then in that case, what happens is the partner who complains of any wrongdoing is not liable. But here, under the limited liabilities partnership, there is a separate institution called LLP Act of 1969. Like a loose joint stock company, the partners limit their liability to say that they are liable only to such an extent and not above that. But irrespective of all these things, the incidence of partnership is an individual partner's liability is joint and several. There is no question of limiting his liability if he comes under the Partnership Act. That is what I've replied to also in the return message which I've given. I think you can also check up, sir. Here, I'm really happy that this question was asked because it itself shows that you are going through my lecture very, very carefully. I have repeated that particular topic twice or thrice, though it does not form part and parcel of the Negotiable Instruments Act. We have completed up to section 39, and the next section is section 40, discharge of endorser's liability. As far as the endorser, the person who is the drawee endorses it in favor of another third person called the endorsee through a transaction called endorsement. All the rights and duties of the drawee comes to an end, and he is not bound by any liability. And the question is, the drawer becomes responsible to the person to whom the endorsement has been made or the endorsee. Of course, these are all academic sections, please. Most important sections have dealt with it yesterday as far as golden presumptions of the under the Negotiable Instruments Act and the procedure to be followed under section 138. Then we go to section 141, which says acceptor bound through endorsement. Acceptor bound through endorsement. That means when a bill or a NI has been endorsed in favor of a third person, the question is endorsement binds the acceptor, and the acceptor, for all practical purposes, cannot make the drawee responsible, but he can proceed against the drawer and then recover his money. So once acceptance has been made, I gave you the quotation also. An acceptance is to an offer what a lighted match is to a train of gunpowder. Here, next one is the acceptance of bill drawn on fictitious name. Acceptance of bill drawn on fictitious name. What do you mean by acceptance of bill drawn on fictitious name? The person is also not existing. His identity is not known. Who the acceptor is, we do not know. And then in the sense who has drawn the bill, we do not know. The person who is there, his name is not certain. In that case, it does not amount to an acceptance at all. Then section 43 deals with made without consideration. If you see the Contracts Act, section 2D says a contract without consideration is a nullum pactum and it's a nullity and it's unenforceable. Suppose the negotiable instrument is not supported by consideration, the instrument fails. Then that's why I said I gave more emphasis to section 142 of the NI Act, which says there must be a pre-existing monetary liability followed by a check issued towards discharge of the monetary liability. That means, what do you mean by existence of monetary liability? That means a receipt, promissory note, or anything must have been executed prior to the check being given. Then that document also has to be filed. That is the primary document which shows the liability, and towards the liability the check is given, and the check when presented for payment gets dishonored. So it is said when there is no consideration, the question is the instrument fails. Then we go to 44, partial absence of a failure of money consideration. Partial absence of failure of money consideration. That is, it's not complete, but partially, to some extent. To the extent which remains, then in that case, the document is enforceable. These are all academic sections, please. It need much emphasis need not be gone into. Then we go to 45. It says partial failure of consideration. That is consideration not consistent with money. This also we can omit. So 45A says that right to duplicate or lost bill. Suppose the bill is lost or the bill is not traceable, or let us say then in that particular case, the holder has got a right of applying for duplicate bill. This is as far as chapter 3 is concerned. Then we go to chapter 4, which deals with negotiation or transferability rather. First one is 46. How a bill, promissory note, or etc. is completed, sir. It is by delivery, handing it over physically to the endorsee. The delivery is complete. Then negotiation. Next section is negotiation by delivery. There is a promissory note. What all the drawee had, it gets passed on to the endorsee after endorsement, and the original documents are handed over to the endorsee. That is what is called by delivery. If it's handed over, that is sufficient. Then next one is negotiation by endorsement. What do you mean by how a transfer is made, sir? Transfer is made by the drawee endorsing it or transferring it in favor of the endorsee by a transaction called endorsement, and notice being given to the debtor that the endorsement has been made and the endorsee is your future creditor for all practical purposes. Then next section is section 49, conversion of endorsement. Here it is said, please remember, conversion of endorsement means, here this also you can, the effect of endorsement is, that is once the endorsement is made for all practical purposes, the drawee goes out of the picture and the endorsee becomes entitled to claim all the rights which the drawee would have had against the drawer. Then next one is who may negotiate. Then the question is, I think, here I deal with what is called privity of contract. Here, who may negotiate means the drawee alone can endorse. Drawee alone can negotiate. Drawee alone can make the endorsement. Why? Because he is the person who is entitled to the amount due and payable under the promissory note or under the check which has been given. So the question is, once the endorsement has been made, the endorsee becomes entitled to all the benefits which the drawee would have had prior to the endorsement. Then the section 51 is who may negotiate. The question is, as far as negotiation is concerned, it can be done only by a party to the contract. The party to the contract being the drawee, he alone can endorse, none else can do it. Then endorsement excludes his own liability or makes it conditional. So the question is whether you recover the money or don't recover the money. I've already made the endorsement in your favor. It is your headache to proceed against the drawer and then recover your money. That is what is called 52. Then 53 is holder deriving title from holder in due course. Suppose the holder gets title by the from holder in due course. That is, who is the holder in due course, sir? The holder in due course is the transferor or the drawee. When he comes into possession of the endorsed document, he becomes entitled to all the benefits. Then 54 is blank endorsement blank endorsement instrument. What do you mean by blank endorsement instrument? It means it contains only the signature and the date of the endorser, but all other things is I'm here with endorsing the negotiable instrument in your favor. That word is missing. The effect of it is perhaps when if it is questioned, the question is it may not be enforceable. Then 55 deals with what is called conversion of blank endorsement into endorsement. Suppose, let us say, at the time when the endorsement is made, it was not filled up. Later on, before issuing the notice to the debtor, it is filled up and handed over to the endorsee. It is definitely enforceable. Then endorsement on part of the sum due, that is 56. Please remember, here I draw your attention to the promisor note, sir. In the promisor note, what happens is, suppose the promisor note is drawn for, let us say, 50,000 rupees. Out of that 50,000 rupees, 10,000 rupees has already been paid on a particular date. Then on the reverse of it, please remember, as far as villages are concerned, they are not that literate as you people are. But in the villages, what they do is on the reverse of it, ఈ రోజు నాకు 5,000 రూపాయలు రొక్కము ముట్టినది. That is, on this particular day, the date is fixed, date is mentioned. I have received 5,000 rupees from the drawer. Then what will be the amount due, sir? Amount due under the promissory note is 50,000 rupees. Out of 50,000 rupees, 5,000 has been paid. Then what will be the amount due? It will be 45,000. So the endorsement will be made only to the extent of 45,000 and not 50,000, because 5,000 rupees has already been paid. Then, sir, instrument legal representative cannot be only to negotiate instrument. Here, as far as legal representative is concerned, cannot effect delivery, only negotiate instruments and so on. So even a legal representative on behalf of the drawee can negotiate and then transfer the instrument, but beneath it you must write that my father is dead and gone. So on my behalf of my father, I'm endorsing this document, endorsing this NI in your favor, Mr. Endorsee. That endorsement has to be made and it has to be signed by the legal representative with a particular date. And then next one is instrument obtained by unlawful means. As far as an instrument is concerned, if it is obtained by coercion, undue influence, misrepresentation, fraud, or mistake, unilateral and bilateral, that is voidable, and it can always be set aside by court in a suit filed for cancellation of instruments under 31 to 33 of the Specific Relief Act. Then next one is instrument obtained after dishonor or when acquired after dishonor, or where something, that is, suppose the instrument has been dishonored, that means it has not been cashed, no amount has been paid, the check has got returned. Even after that, the endorsement can be made in favor of the endorsee, and the endorsee becomes entitled to all the benefits which the drawee had. And section 60 deals with instrument negotiable till payment or satisfaction. Sir, what is the lifetime of an endorsement, sir? The endorsement or the instrument is valid till such time the entire money is paid, due and payable under the NI. This is chapter 4. Then we go to chapter 5 that deals with presentment. The heading of the chapter is presentment. Presentment, the section 61 says presentment for acceptance. As far as the bill of exchange is concerned, the bill of exchange has to be presented to the acceptor, and the accept, that is when third person makes the payment, and then he has to accept it and then says, I'm prepared to take it. That is the presentment for acceptance. Then presentment of promissory note. The promissory note which has been endorsed can be endorsed in favor of the endorsee and handed over to the endorsee by delivery. Then 63 deals with drawee's time for deliberation. Once the notice is given, the drawee can take time for deliberation. Then presentment for payment. Please remember, no instrument is valid till it is presented for payment at the appropriate place. Then hours of presentment. Please remember, you cannot present it at any time you like. Normally during working hours of the bank or working hours of the the drawer, you will have to present it. Then hours of presentment. Hours of presentment means it is only during business hours it can be presented. And once it is specified that the bill or the promissory note has to be presented for payment at the office and the business premises of the debtor, then it has to be presented there. But if it's some other specified place, it should be presented at that place. Then presentment for payment of instrument payable after date of sight. That is, suppose let us say after date of sight. What do you mean by that? It means suppose let us say he is not found, when should we present it? That's what section 66 says. Pro note payable in installments. But sometimes what happens is a promissory note is executed, receipt is executed, but there is a subsequent document to say that the amounts due and payable under the pro note is not payable immediately, but it is payable in installments. Then both have to be read in conjunction with each other, and it have to be received in installments. Then 67 is then next one is 68 is presentment of instrument payable at specified place. I've already discussed it. Then payment at specified place, payment where no exclusive place. Suppose the payment is no period is no place is mentioned where it has to be presented. Normally it is presumed it has to be presumed it has to be presented at the place of business of the lawyer. Then we go to section 72, presentment of check or check drawer. Checks have to, please remember, just by keeping a check with you, keeping it in a locker is no, it's not sufficient. What you have to do is you must present it before the bank on the specified date and then draw the money. That's why they said checks have to be presented to the bank on which they are drawn, and only on such presentment and refusal by the bank does any recourse to drawn can be drawn in favor of the holder. Suppose, let us say, you have the check with you. You have not presented for payment. You have to present it before the bank for payment. You don't present it, then the question of liability of the drawer does not arise. The next one is, what is the difference between drawer of bill and check? In the case of ordinary bill of exchange, negligence in respect of presentment discharges the drawer. Suppose, let us say, the bill has to be presented within 90 days. You don't present the bill for acceptance or you don't present the bill for payment. Then in that case, if you are negligent as a endorsee or as a drawee, it lapses and you cannot recover anything. Then go to section 73, sir. Presentment of check to charge any other person. Check must be presented within a reasonable time and after delivery thereof by such person. Please remember, suppose a check is given to you. Unless you present the check, you cannot keep it in your locker and say, I'll present it whenever I like. 3 months period is given for presentment of a check ought to be valid. Then in that case, within the 3 months period, you must present the check. If you don't present it, the question is, the drawer is not responsible in any manner. Then 74 is instrument payable on demand. Which is instrument payable on demand, sir? It is a promissory note. Whenever I like, within the period of 3 years, I can always present the instrument and ask you to make the payment. That is why it is said. That's why the wording which is used in a pro note is on demand or order. So whenever the demand is made, I need not wait. I can make the demand at any time. And once the demand is made, the payment should be forthcoming. That's what 74 deals with. Then 75 deals with presentment by agent or representative of deceased or assignee of the instrument. The same rules apply. Either the LR can present the instrument or the assignee in case of insolvency, that is diwala as you call it, bankruptcy, or the agent, because every agent is supposed to be an authorized representative of the principal. They can present the document. And suppose there is a delay, like any other enactment, on sufficient cost being shown, the delay can be condoned. Then 76 is when presentment unnecessary. When drawer or acceptor intentionally prevents presentment. He tells the banker, sir, don't accept the instrument. Don't accept the instrument for payment. Don't stop the payment. Or let us say, don't allow that person to come and present the check. Then in that case, it is said, no, that's why it is said when presentment unnecessary. Second one is when payable at the place of business. Suppose, let us say, it is payable at the business place of B and B abscond and is not found during business hours, you cannot present it. Then no, the presentment is not necessary. then or let us say there is no attendance at any other place which is specified, then in that case the presentment is unnecessary. Then let us say the drawer is not to be found in spite of best efforts, then presentment is not necessary. Then if against any party sought to be charged, if he is engaged to pay after maturity with that knowledge that it has not been presented, part payment or so and so, so and so. So the question is, once this has been agreed that the amount will be paid in part and in installments, there is no question of necessity to present the instrument. That is what 76 deals with. Then 77 deals with liability of banker for negligence. Suppose, let us say, the banker, though receives the check for payment, doesn't honor the check, though funds are available, or he deals with it in such a manner, forgetting about the payment, then in that case, banker is liable to compensate the person who presents the check. And that's what section 77 says, which fastens the liability on the banker. Now you know there is a parallel enactment also, the Consumer Protection Act. The question is, the banker also can be made responsible for negligence on his part, not honoring a check which has been presented. Then 78 says, to whom the payment has to be made, sir? The person who is the holder of the check, the person who presents it for payment, the person who presents it for payment to the bank, and that person is entitled to it, and payment has to be made to him. And 79 is interest when rate specified. As far as the NI Act is concerned, section 79 says it has now been amended, whereby they say the interest on the amount due is charged at 18% per annum if the amount is specified, and the interest is calculated on the principal amount. Please remember, not the accumulated amount, but the principal amount. Then the next section says if no interest is mentioned, then it is to be awarded at 18%. So this is what the small sections of the NI Act from section 40 to 80. Please remember, I laid more emphasis from the practical point of view of advocates, and yesterday also narrated it for people who didn't attend the previous lecture. I repeated it also. Now we go, I don't intend to repeat it again, please. Now we go to section 81. Any person liable to pay and called upon by the holder thereof to pay the amount due under pro note, bill of exchange, or check is before payment entitled to have it shown, and it is on payment entitled to have it delivered to him. And if the instrument is lost or cannot be produced to be indemnified against any future claim of the check, or is an electronic image of the truncated check, even after the payment, the bank can retain the check even after payment, and an electronic printout is prima facie proof of such payment. Suppose, let us say, bank has already made the payment on the instrument being produced, but let us say the instrument is mutilated or so. But please remember, nowadays all payments which are made, now we are in the electronic age, a printout can be given, and printout which is given by the bank in proof of payment is prima facie proof that the amount has been paid, and the electronic image is sufficient to discharge the drawer from liability. That is what 81 says. Then 82 speaks about discharge from the maker, endorser, or acceptor of NI is discharged from liability or cancellation to holder who cancels such acceptance or endorses with the intent to in all parties by release. So here it is said discharge from liability. Once the maker gives up his rights, or let us say he cancels the instrument which is given to the holder, then in that case, all liabilities come to an end. Then 83 deals with what is called discharge by allowing drawee more than 48 hours exclusive of public holiday to consider whether he accepts the same, and all previous parties not consenting such allowance can be discharged from liability. Let us say it's a partnership firm and the instrument is signed by all the partners. Then in that case, if the acceptor or the what is called the drawee of the check refuses to accept it, then the persons are discharged from their liability. I think this should close the NI Act, because all the other sections which are there are all what is called academic sections. Much emphasis need not be laid to it, and more emphasis has to be laid from your practical point of view There is the golden presumptions of NI as laid down in section 118 and the procedure for initiating proceedings under the section 138 to 149 or 150 of the NI Act. I think that is sufficient as far as the NI Act is concerned. Now, I intend to proceed. చెప్పండి. Please hold your question until the interaction session starts. I request you for that. Madam. So please go ahead, sir. Yes. Now we deal with another topic called drafting, pleading, and conveyancing. Drafting, pleading, conveyancing, and professional ethics. Drafting, pleading, conveyancing, and professional ethics. Yes. Over. No balance. Sections are only actually sections. Not necessary.
We didn't give any advertisement for that purpose.
No, parvaled. So now we deal with the smaller topics for drafting, pleading, conveyancing, and professional ethics. Please remember, it's an oft-repeated circulars which is given by the Bar Council from time to time as to regulate the behavior of the bar as well as the bench, as well as the ethics that have to be followed by the bar as well as the bench. As far as the bar and bench are concerned, they are twin children born to the mother called law and administration as far as judiciary is concerned. Both have to cooperate with each other. Both have to have respect for each other. Both have to have admiration for each other. No one should feel that I am superior, the other person is inferior. The real friction starts when the advocate concerned exceeds his brief and then misbehaves with the presiding officer. Please remember, we are all advocates, sir. Whether you like it or not, we have to tolerate the judge who is on the bench, give respect to the bench, and also act in a dignified manner, act with decorum, and act with discipline, and also conduct yourself in a proper way. As far as ethics are concerned, the first and foremost rule is that try to respect your fraternity first. Think that all the other advocates who are there along with you in a particular bar association or who are associated as far as you are concerned in the courts where you practice, treat them with dignity, treat them with respect, and treat them with decorum, and also see that you don't indulge in indiscipline, irrespective of your caste, color, creed, or race. Please remember, second thing is don't make any comment which hurts a person as far as his community is concerned, or as far as his race is concerned, or as far as his learning is concerned. Please remember, all of us do not possess the same IQ because some of us come from the vernaculars. Our knowledge of English is not that much as your opponent has. Just because your knowledge of English is not sufficient to address the court, the other side should not ridicule you. Other side should not other side should not laugh when you try to argue or when you try to cross-examine a particular witness. Please remember, if you are superior to me, keep your superiority yourself and don't exhibit it in order to belittle me before the court. The first thing is have respect for your brother advocates, irrespective of caste, irrespective of sex, irrespective of religion, or irrespective of the denomination to where he or she belongs. That is what is called samajika nyayam in Telugu. The question is, you must treat the advocates with respect, dignity, discipline, and also not mock at them when their knowledge is insufficient to meet the demands. Second one is, whenever you enter the court, you try to bow before the court and try to salute the court. Please remember, it does not mean you prostrate before the judge. No, it is sufficient if you show respect to the presiding officer, because so long as the presiding officer, you have to show respect. And that is the reason, sir, when the judge comes, the attender says, Ushar Ojaiye. That means all of you get up and respect the court and then sit down. Once the judge sits down, you also sit down and then start your proceedings. Third one is, one more thing I would like to make out is, there is a circular of the High Court or the various High Courts that the colonial way of representing before a court has gone now. Previously, used to say, Your Honor, Your Lordship, My Lord, and all these things. Please remember, when you are in the lower court, it is sufficient if you address the court as Sir or Madam. I got into trouble with one of the women officers who was presiding over the family court at Secunderabad. When by mistake, what I did was I addressed her as Sir. Then she got irritated and said, "Do I look like a sir? How do you call me sir? You must call me madam." Then I told the judge, "Sir, we are used to call addressing courts as sir only because mostly male judges are there. Whenever female judges are there, we give them equal respect and they treat them on par with the male judges." But the judge said, in a humorous way, "Suppose I call you madam, how do you feel?" I also replied in the humorous way by saying, "Sir, I feel very happy that you call me madam because someone recognizes that I've got some effeminate qualities in me." So that's where it ended. See, next time and all, don't try to address me as sir, address me as madam. But if you see the attendants who call the names of advocates outside, they say, they say, Varalakshmi sir, Azire, that means Varalakshmi advocate and Jepodu. Varalakshmi advocate Azire, then he doesn't say Varalakshmi madam. Please at least have that respect. The attendant also should have respect to the advocates. But the question is, now the attitude has been, most of the youngsters who are coming to the profession, they wanted to curry the favor of the magistrate or carry the favors of a junior civil judge by calling them my lord or your lordship. Please remember, my lord, your lordship, and your honor is a colonial expression which has gone, and now you can call the judge as Mr. Judge, or you can call them as sir, or you can call them madam. That is sufficient. Third one is, we must always remember the bench and the bar are two children born out of a common mother called the judiciary. The question is, you must show respect to the court, you must act with humility, you must not make any aspersions as far as the judge is concerned. And that means aspersions in the sense the integrity, the ability, or the way he or she understands the matter. Fourth, never antagonize a judge when you are arguing a particular matter or conducting a case. Why? Because don't forget for a moment the judge has got the pen in her hand or in his hand. He can always write against you. He can always take that antagonism to the extreme extent. That is the reason, be polite as far as possible. And fifth one I told you is, don't ridicule the opposite side when he argues or when he conducts the cross-examination, because the question is, he or she may not match your intellect and have your intellect to yourself, and you have no business to insult or annoy the opposite side. Sixth one is, whenever a witness is in the witness box, first and foremost is, you study the psyche of that witness, whether it's a timid witness, whether it's a truthful witness, whether it's a 50-50 witness, or whether he's an idiot. Or fifth one is, he is trying to test your capability of conducting the cross-examination. And don't try to put questions which annoys or harasses or insults the witness. Why? Because tomorrow the same witness may be your client. He may come to you because he appreciates your knowledge, he appreciates your skill, he appreciates your style of cross-examination, he appreciates your style of respecting a witness. Please remember, just because a witness comes to the court doesn't mean that it gives you a license to insult or annoy him. Please be very, very careful on this particular aspect. Then the next ethics which you have to follow is, treat your client with respect, treat your client with friendship, but don't go to the extreme extent of taking your case personally on your head and trying to see that you show your personal anger against the opposite side. You have to always oppose it. You must always control your temper when you deal with the other side. Please remember the other side is doing his duty and you have to do your duty. And you have no business to hurl invectives or insulting words on the opposite side and call him by various names. Then next one is the dress code. Please remember nowadays we find, of course I'm not saying about gents, sir. Even gents also come with jean pants and they come with Hawaii chappals and they don't come with proper coat. They don't come with bands. As far as lower coats are concerned, you don't require a gown. At least come in clean dress up yourself properly, and then present yourself properly. And then when you address the court, address it with respect. And don't forget for a moment, you don't lose anything by showing respect to the court. I'll put the other way around also, sir. When you say professional ethics, it also applies to judges also. Judges also should be very, very polite. Judges should be very, very gentle. Judges also should not hurl any abuses based on religion, caste, sex, race, etc. For the he must have equal respect to all the advocates, whether junior or senior. And as a junior, you must show respect to your senior. Whatever instructions are given to you by your senior, whatever writing is given to you by your senior, whatever work you have to carry out as far as your senior is concerned, whatever dictation you have to take from your senior, take the dictation and then use it for your own benefit tomorrow as and when you practice independently. These are the few rules of ethics. They are not exhaustive, but some of the ethics which I want to point out before we go to the topic. They are called professional ethics. Then another thing is, in this profession, we have got lot of temptations. The question is, your client is your God. Your client is the person who hands over the brief to you. He comes to you with trust and confidence. Comes to you with confidence that you will deliver the goods. But in that case, don't try to betray the confidence which your client has on you. So this is as far as the few points of professional ethics are concerned. Then one of the students earlier, I think I'm corrected with Gauzia or someone, I don't know. They asked me a question, sir, how to draft the pleadings, how to draft a document, how to what should be the style of drafting, etc. This because I wanted to start. I only gave you a lecture on professional ethics. Tomorrow when we come, I'll be dealing with drafting, pleading, and conveyancing. Now the period for interaction starts, please. Mr. Venkat? Mr. Venkat? Are you there?
Yes.
Please, your question, please. Your question, please.
He's asking,
Just a minute.
just a minute, Venkat, but 1 second.
1 second, sir.
Yes. Yes, Mr. Venkat. Yes, Mr. Venkat.
Sir, if at all, if the drawer instructs the bank to stop the check from payment
Yes.
to the drawer, so in that case, how you need to?
It also amounts to an offence under 138, sir. The drawer has no business to instruct the banker to stop the check. He can do so only when negotiations take place, when the question of some payment is made, or the payment is to be made in installments. Only in those cases he can stop the payment. Otherwise, stopping payment also amounts to an offence under 138, please. Yes.
So in case of one more question, sir, it's in case of if the drawer is abscond and he is not.
If the drawer is absconding, then the question is if a publication has to be made in a newspaper and proceedings can be initiated. And like CPC, you can always give a publication in a newspaper. Even after that, he does not come on merits, the court can dispose of the matter and his estate becomes liable to pay the debt, whatever is due under the instrument, please.
So in that case, if the address was not found to which address the summons has to be sent, sir.
Then the address has to be sent on his last known address. General Process Act says the last known address which is given is when the notice is sent to that particular address, the service is sufficient. It is laid down in the General Process Act itself, the last known address of the party.
So in that case, if it is not even delivered to him also, then it can be.
If it is not delivered, you can take steps by getting it published in a newspaper which is circulated in the area where the debtor stays. And preferably a national paper. Yes?
Thank you, sir.
You're welcome.
Thank you.
Sir, can you explain about section 43 again, sir?
40?
Section 43 is a negotiable instrument made, etc., without consideration.
Here, the Contracts Act section 2D says, any contract without consideration is a nullity and a nudum pactum and cannot be enforced. That means if the debtor pleads that though the promissory note is drawn by him, it has not been drawn properly, the amount has not been mentioned, no amount has been paid to me, there is no passing of consideration, I have not executed the document, it's a fraud. Or I have initiated steps to get that document set aside by filing a suit under 31 to 33 of the SRA, that is a specific relief act, to get it duly cancelled. On those grounds, the claim made by the debtor or the lawyer is maintainable, sir. Very rare, sir, I tell you, you execute a document and say that you have not received the money, no one will believe you.
Sir, practical sections, can you just repeat, sir, negotiable instrument?
Practical sections is section 118, golden rules of presumption, and the procedure from 118 NI Act.
Okay.
That is golden rules of presumption.
148, no, sir?
118.
118, then?
Then 138 to 150.
Okay.
Then one more section which is important for you, section 4, which defines a promissory note, bill of exchange, and a check. Then endorsement, so on and so forth. But one thing you must remember, sir, suppose a check is not crossed. Someone finds a check. It can be treated only as a bearer check and not as a cross check. So crossing, when it is done, you endorse it with words called and co or account payee only. And a cross check is payable not across the counter, but it can be paid only by sending it for encashment and not otherwise. But a bearer check, which is found on the road, any person can draw the check. And 138 to 150, yesterday I repeated it 3 times, and for your benefit again I'll repeat. That is 118 is a very small section which talks about the presumptions under the NI Act, or they are called the golden rules of presumption. The word that is used is shall. Then first is presumption as to time and place, presumption as to the date, presumption as to the drawer, presumption as to the drawee. 5th one is the presumption as to execution. Then 6th one is presumption as to consideration, and the person holding the instrument is a holder in due course. There are the 7 golden presumptions laid down in section 118 of the NI Act. Then 138 is, of course, the procedure when a check gets bounced. What should you do? Well, you must give a notice under 138. Again, 138 has to be read along with 142. That means 142 says there must be a pre-existing monetary liability to support the instrument. That means there must be a promissory note, or there must be a bond, or there must be an MOU, or there should be a receipt which says there is a pre-existing monetary liability. And towards the monetary liability, a check has been given. And the check, when presented for payment, has got dishonored for various reasons. And once it is dishonored, within 15 days, you must give a notice. Then in the notice itself, you must specify that the instrument has been given for honoring a pecuniary liability, and a check has been drawn and given to you to honor that liability for payment. And when check presented for payment has got dishonored, you have received the bank memo from the bank, and the bank has endorsed for various reasons the check has got returned. Then the question is, you have to give a notice giving at least 15 days time to the drawer to make good the payment. If he does not make the payment within 15 days, then you can file a proceeding before the concerned magistrate within one month from that day. That is 1.5 months is a period within which you must file a complaint. And then once a complaint is filed before the magistrate, he or she takes cognizance of the complaint, records the sworn statement, and then makes the gives a number to that particular case, and then summons are issued to the accused, and the accused will have to be present on the day fixed at that particular time. And first thing is examined under section 157, whether 157 or 257, whether he is guilty or not guilty, and then the case starts. That is, the question is, evidences on both sides are recorded, and then after the evidence of the complainant is over, it will be posted for what is called 313 examination. Based on the statements given, the accused will be examined whether he pleads guilty or not guilty, and the defense is given an opportunity of leading his defense evidence, and after that, the arguments are heard on both sides, and then the matter is disposed of accordingly. I also told you yesterday that 139 is only in Chennai, the double the amount is fixed. That is, when the check fails, when a complaint has been filed, the question is, the court orders for payment of double the amount. One amount goes to the complainant, and the other amount goes to the.
Galaxy A5, please mute your things.
The other,
sorry.
The other amount goes to the state by way of fine. Then 142, I already told you, pre-existing monetary liability. Then from in 2018, 143 to 149 has been added, whereby they say the question is, once the accused is acquitted of the charge and the case of the complainant fails, the question is, the accused is discharged of all liability. And 143A says is, whenever the amount of interim compensation is paid as per the orders of the court, that amount will be has to be refunded by the creditor to the debtor within 60 days. Then next provision is how the summons have to be sent. Summons will be issued to the accused by the court and to be delivered at the business place or the residence of the accused. Then there's one more provision which has been incorporated, which says that the question is interim compensation, because the case takes sufficient time, interim compensation also can be awarded by the court during the pendency of the proceeding, and it has to be paid by the debtor to the creditor, and it's normally 20% of the amount covered by the check. Next one is, if the accused is convicted of an offense and fined, the fine amount has to be paid, and the court can suspend the sentence of imprisonment only on the accused depositing 20% of the check amount into the court. And then next one is, it says all evidences before the NI court is by evidence affidavit. What you follow in the civil court, it is also followed by the magistrate. And then last one is, for a negotiable instrument means only promissory note, bill of exchange, and check, and nothing else. This is what all we discussed for the past 2 classes. And the other sections I went from an academic point of view, because it doesn't require much explanation, and it is only by way of academic consumption the sections have to be gone into. I'm making myself clear to sir.
When a check is given without date,
Yes.
what happens after if it's date and present in the court?
If it is given without date, mostly I think you are giving too much of importance to that. Please remember, when a check is given, normally a blank check is given which the creditor fills it up, and he puts a date whatever he wants. And especially if the check is given to a banker, the banker puts the rubber stamp there.
But when it is okay, when a check is given by the drawer, if it takes a photograph of that and gives you, or keeps a Xerox of that and gives you, then it tells that I have not put the date.
If he has not,
name I have not written.
Please remember, that's why section 118 says, even if the date is not there, the presumption of time and place is important, sir. It's very, very rare. I think your cases you are talking about Harishchandra's days, when only truth prevails.
No, my point is, when the fellow takes a Xerox copy of the check and gives you without date,
Xerox
and
copy.
your name, and later you'll put your name and date.
Sir,
then you say that, no, when I given
sir,
this.
when will the Xerox copy be given, sir? The original will not be filled up. I go to the extreme case. Original is not filled up. Date is not filled up, but the signature is there. The creditor himself
Yes.
puts the date. Creditor himself, he fills up the document. But normally, what the creditor does is, that is why they say, sir, a beggar cannot be a chooser. When you go for begging, you have to succumb to the whims and fancies of the creditor. The creditor asks you to write it in your own handwriting. And then please remember, you never hand over the document to you, no Xerox copy is given. It's very, very rare cases that Xerox copies are kept. Of course, what you say is absolutely right. Suppose before handing over the check, he takes a Xerox copy and then does it. Then the question is, it can produce a Xerox copy as a secondary evidence under 65B of the Evidence Act. But the question is, it has to be certified that it has to be taken from the original check. There's a big procedure for it. It's very, very rare, sir, such situations. Yes.
Total sections 148, sir. 150 you're telling? What
150 are the small residuary sections, sir. I think it is in my old book, and even in the Google you get it.
Yeah, but I have a book with a 2022. It's only up to 148.
149, 150,
No, 149.
149, 150 are all residue sections, sir. Perhaps they are not there now.
I don't find that section.
No, they are not there now. Only thing is, again, they define what you mean by instrument. They say promissory note, negotiable, promissory note, bill of exchange, and check, and nothing else. But they are not there now after the amendment.
Mr. Srikanth.
Next.
Hello, sir.
Yes, sir.
Sir, in case if the branch where the check is drawn is not available, just say that the branch is shifted to another location.
Yes.
So how to proceed in this case? We cannot present that check, right?
No, it is within 3 months at any time you can present the check, sir.
No, the branch office, the bank branch is not there at the location.
You will have to search it out, sir.
Search it out. You can present number of times in 3 months.
Yes, you can do it, but you have to search
on
it
request of the drawer also, sometimes we represent again.
No, but you will have to search out where the branch is shifted.
Muralidhar, he is asking is a simple different way, sir. He is asking the branch is relocated, then what is my position?
Even if it's
If it is relocated also, you should come to across in such a way. You can search for the nearby. The jurisdiction is not so small. The branch will shift within very near to that.
I think you are talking about the bank which was recently shifted.
No, he will present to his bank, sir, check.
No, his bank, wherever his location is, then naturally he goes not only for this instrument, he goes for depositing his own money, isn't it, sir?
Yeah, that's what I'm telling you. When he deposits check in his bank, how it is not traced?
No. He's asking about. He's trying to pull his the client to his jurisdiction, Mr. Srikanth. Am I right?
Don't know, sir, but so my client went to present the check at the given location, but the bank is not presented there.
Not located there.
See, there are a number of branches who are moving here and there, but still you can find it out in nearby.
You can find out from the head office or the regional officer. You'll get the branch wherever it is located, or even if
there are certain branches who are been located in. I'll say for an example, Secunderabad, there is a Union Bank of India which is relocated to SD Road. So SD Road and Secunderabad both comes under Secunderabad jurisdiction only. So where and then you have to present the checks wherever it is possible.
Then you will have to liaise with the head office and try to find out where it is shifted.
Google will direct you, sir. No problem.
Google also will give you the present address.
Sure, sir.
Thank you.
Thank you.
Anything else? Any more questions?
Sir, good evening, sir. This is Anuradha.
Yes, madam.
So the drawer issues the check, blank check.
Ma'am, you are not audible, madam. Please be loud.
Yeah. Sir, is it okay now?
Yes, madam.
Yeah, the drawer issues the blank check and the drawer by mistake loses it. And it hands of a third person and he encashes the check.
Yes.
So, in this situation, does this exclude the liability of the drawer or does it
It's total negligence.
It is negligence, madam. He has to suffer.
There's no other go.
And if it's a cross check, of course, the person who finds it cannot cash it, because the question is cross check can be payable only to the person in whose favor it has been drawn.
Yes, I understand.
Yeah.
Thank you, sir.
Welcome.
Thank you. Anything
Always
else?
I advise everybody to cross a check. Whenever you issue a check to anybody, just cross it. Then you need not worry about that.
I do it for even 10 rupees. I cross the check and give it.
Okay, sir.
Any more questions as of now?
Sir, this is Koteshwar Rao.
Koteshwar
Once a
garu
check is given, that is written, then only one can go to the court by issuing notice, etc. But whereas if the debtor doesn't make the payment or he does not issue a check, then how to go about it?
See, sir, here I told you that first and foremost is there must be a pre-existing monetary liability under 142. And originally the promissory note and receipt is executed. And towards payment, the check is given. Towards the pre-existing liability, the check has been given. And when the check presented for payment has got dishonored for some reason or the other, then the cause of action which gives you is 142. Towards the pre-existing monetary liability, a check has been given. And when the check is dishonored, you, for any reason, you can always initiate action under 138.
Promissory note is there, sir. He does not make the payment and he does not issue a check even.
It's very, very rare.
Respond.
It's very, very rare, sir. But you have got such dishonest people also. Please remember, creditor also is equally clever, sir. Because when he indulges in money lending transaction, he'll take the normal precautions which he would take in his business, isn't it, sir?
Good evening, sir.
Good evening.
Sir, my question is, sir, NI Act case, accused absconded, sir.
Yes.
The time complaint petition filed for proclamation eligible for CRPC, sir.
Eligible, sir. The question is, once a proclamation has been made and still he is not found, the question's case will be decided on merits and an award passed accordingly. If you are able to prove and establish your case, and then you can proceed against the estate of the person and then recover your money.
అంటే ఇప్పుడు మనము సార్ ఒకటి చిన్న స్మాల్ డౌట్ ఏంటంటే ఇప్పుడు అబ్స్కాండెడ్ అయితే ప్రాపర్టీని అటాచ్ చేసుకోవచ్చు ఆ ప్రొక్లమేషన్
చేసుకోవచ్చు. But unfortunately in NI Act you don't have execution procedure. You have to
before judgment, sir, after judgment.
No, after judgment. Suppose after judgment you visualize the situation. No procedure for attachment, sir.
You can only go through only civil case.
అంటే ఇక్కడ ఇంట్లో క్రిమినల్ లో కూడా ప్రొక్లమేషన్ వేసుకోవచ్చు అని వారు చెప్పారు.
CRPC
ప్రొక్లైనింగ్ వేయచ్చు సార్, బట్ ఏదైనా అటాచ్మెంట్ చేయండి అంటే నెగోషియల్ ఇన్స్ట్రుమెంట్ లో అవ్వచ్చు, NI Act లో అవ్వచ్చు సార్.
ఓకే సార్.
ఇట్ ఇస్ ఓన్లీ త్రూ సివిల్ కేసెస్.
ఓకే, థ్యాంక్ యూ సార్.
Sir, so one last question, please.
చెప్పండి శ్రీకాంత్ గారు.
Sir, so debtor gave one check and his surety also gave one check. So if debtor check is bounced, so should we present immediately the surety check?
Both the checks have to be presented and then you must make both of them jointly and severally liable for the transaction.
Okay, sir. Thank you.
Any more questions? All right. Thank you.
Drafting, pleading, and
All right. So from tomorrow onwards, drafting, pleading is coming up. So make your papers, pens, everything available.
Thank you, sir. Once again, happy way.
So from tomorrow, drafting and pleading is coming up. Please make a kind note of it. Make your things ready. And then we go ahead according to the class.
drafting, pleading, and conveyance.
Conveyance also, as he says. Thank you. Thank you, one and Azan. We'll see you again. Thank you much. And once again, thank you for all the pieces who are made me on the online. Thank you very much.
Thank you very much, sir.
Bye.